We've taken the position that the stay should not apply to those, that Kouri should be able to pursue those claims, but that other claims, the remaining claims in that case, should be stayed.
I feel like it's going to have unintended consequences that I can't quite identify at the moment. Okay, I understand your position.
Yeah.
What is the case number in that case?
It ends in 7-6, I believe.
Okay.
Your Honor, it's 220500076.
Thank you. Okay, I appreciate it.
Yeah, thank you, Your Honor.
Mr. Kouri.
Yeah, and just another point of clarification. So there's also the case ending in 230, which is Kouri's case against Katie in her capacity as personal representative. Now that case arose from the probate case, right? So the genesis of that is, in the probate case, Kouri files a claim against the estate. We disallowed it. Then under the probate code, she had 60 days in which to file a petition for allowance or a separate action. She elected to file a separate action. So now we have what we've called the estate case pending over here, which ends in 230. And I believe that Kouri's motion to stay in the probate case touches on that as well.
Give me that case number one more.
Sure. 230500230.
230500230.
Correct.
All right. Mr. Orange, I, at the moment, acknowledging that I may need to revisit this issue depending upon how much frustration and mischief arises in discovery, am inclined to stay any proceedings related to the petition to determine disqualifying homicide in case ending 019, and to stay case ending 262, the wrongful death action in its entirety, but to otherwise not stay the remaining civil actions or the remaining elements of 019. My reasoning being, there seems to be an immediate need to address what assets are held by whom, what their status is, and whether some changes to that status need to be made. And I think that can be accomplished under the situation I just described. Do you see it differently?
Only in one small respect. Let me address that. That's on case 262, which is the case in which Katie's the wrongful death case.
Right.
So the only issue I would take is with respect to Katie's voidable transfer claims, which you mentioned. Those voidable transfer claims are narrow. They deal with a transfer that occurred just earlier this year with respect to a piece of real property that Kouri Richins Realty transferred to Lisa Darden. There are other defendants in connection with those voidable transfer, and there's also a civil conspiracy claim. And so we can't contemplate how that would come up relative to Kouri's criminal prosecution, simply because it's a transfer that occurred so long after any effect. What's salient for purposes of prosecution, I don't know whether the prosecutors are going to look into that, but it doesn't seem relevant to us. And to the court's point, one of our concerns is trying to get that asset back into the estate. Otherwise, I think we're fine staying the remainder of 262, other than we do want the ability to conduct third-party discovery. That's just the issue.
But I think you could do that. This is why I was pushing Mr. Nate a little bit on proportional discovery in the 019 in the matter of the estate of Eric Richins' case. It seems like you could do that there.
And we don't have a problem. As long as we can go get records from third parties,
Yes.
We're good.
It seems to me that proportional discovery in that 019 matter, conducted by the trustee on behalf of the trusts or the estate's beneficiaries, either the trustee or the PR, right? In the 019 case, the nominal plaintiff is Katie in her capacity as what?
Well, personal representative.
Okay. So in her capacity as PR, I think proportional discovery would be, I need to go figure out what's out there and where it is, and that would include third-party discovery.
And as long as the court's order is tailored to reflect that, yeah, we have no problem with that.
Okay. Have a seat. I'll make sure you get the last word.
All right.
Mr. Nate, did I provoke anything else, sir?
Just one point, Your Honor. I did want to highlight the fact that Johnston Bird, who represents Lisa Darden and Ronald Darden, is here today. In this case, right here, to the extent he has anything to say, obviously wanted to make sure that the court was aware because they are also parties to the 262 case.
That's right.
In Lisa, so I wanted to make sure he had the opportunity to say something.
Thank you. Mr. Bird, anything to add, sir?
Yes, Your Honor. Just briefly, regarding the voidable transfer claims, and that's where our interest lies in this case. This isn't our motion, but we do have an interest in the case being stayed. A lot of it goes to the judicial efficiency of a stay, in that the premise of those transfers being voidable are related to the criminal claims against Kouri and KRR. If KRR and Kouri is, they're found not to have committed any kind of wrongful actions here, then the premise of those transfers having been voidable is disproven and baseless.
True, but under the current state of facts, right now, there's a claim, isn't there, under the definitions of the fraudulent transfer, or voidable transfer act?
Yes, there is a claim that's sufficiently.
Now, that claim will cease to exist, right, if she is not proven guilty.
That's correct, Your Honor.
But at the moment, the claim exists.
At the moment, the claim exists, but it's a matter of pursuing that claim and conducting discovery into that claim, and the eventual possibility of having all of that been for naught if there's later found to be no wrongdoing. So a stay, it's a judicial economy thing, it's also preservation of assets within the trust. A stay would allow those claims to be adjudicated after the criminal liability has been determined, and then we'll know one way or the other whether a basis for those voidable transfer claims exists.
Well, what would prevent a BFP from receiving that piece of property in the intervening period? I think the answer is nothing, right?
Yes, Your Honor.
Then the claim is worthless, you can't get it back. Correct. Okay. All right, I appreciate your position. Anything else?
No, no.
Okay, thank you. Okay. Mr. Gorge, anything else?
Just one quick point, and this is just more of a clarification. I think this is the direction you were heading, but I just want to make sure. So in case 262, Katie's asserted claims both in her capacity as personal representative and as trustee. So if Katie is, 262 is state, and Katie's doing discovery through the probate case as the nominal plaintiff in her capacity as PR.
Right.
Is she going to be able, we just want to make sure she'll be able to conduct necessary third-party discovery in connection with claims that she's asserted as trustee in case 262.
Aren't the duties the same? I mean, doesn't a personal representative have a duty to protect the assets and distribute them lawfully for the benefit of all beneficiaries of the estate? All heirs, not beneficiaries, but heirs.
Certain heirs of the estate,
I mean,
yes.
doesn't a PR have a fiduciary duty to all the heirs of the estate?
Yes,
Doesn't
absolutely.
a trustee have a fiduciary duty to all the beneficiaries of the trust?
Certainly.
Okay.
I just didn't want to run into an objection where we do discovery that is specifically in connection with a claim that Katie only has in case 262 in her capacity as trustee, and we get an objection that
Sure.
in 1.9 it's not relevant to the estate.
Tell you what, if I'm wrong about this, I will happily accept an "I told you so" judge when it comes up in a discovery dispute. But I think I've got this right. Okay.
All right, nothing else.
Okay. All right. Let me try and make a ruling that embodies the court's intent, and I'll ask you if you need any clarification. Before the court are 3 motions to stay, the civil matters, or at least parts of them, pending resolution of the criminal case. Those are filed in cases ending 262, 019, and 076. Those motions are granted in part and denied in part as follows. Case ending 262 is stayed in full with one exception. Plaintiff's claim for voidable transfer was with respect to the real property transfer to Lisa Darden is not stayed. Case 019 is stayed only with respect to the petition to determine disqualifying homicide. All other elements in case 019 are not stayed. Case 076 is not stayed. Case ending 230 is not stayed. Mr. Orange, I think I got that right. Does that sound correct?
Sounds correct.
Okay.
I have two questions.
Please.
Is there a term, and we didn't talk about this, and I should have, is there an end date on the states? I know that, I think.
Not at the moment. I mean, by not imposing an end date, the court is not in any way limiting a party from filing a good faith motion for partial or complete relief from the stay.
Okay. And then I assume that if circumstances weren't, I don't have anything in mind, but if under appropriate circumstances there was cause to move to lift the stay, either party can do that.
I think that's what I just said.
Okay.
Okay. Mr. Any clarification needed?
No, Your Honor.
Okay.
Yeah. So, Your Honor, I think there's one thing that's been overlooked, and Mr. Nate can correct me if I'm wrong. In case ending in 076, which you indicated was not stayed, there were at least a few of those claims, counterclaims, that I believe the parties, I think, probably agreed that should be stayed
Counterclaims brought
by
by.
Katie as trustee, including that a power of attorney was fraudulently signed, that a second mortgage was obtained in violation of her fiduciary duties, all of which came up in your detention hearing. So I think we had agreed that those would be stayed, so
Okay.
we're happy, we could have run away and said, ha, but I think it's better, since we're here, let's just clear it up so we're all on the same page. I don't think either side.
The Katie's counterclaims in her capacity as.
Trustee.
Okay.
Because she is the owner of the home that's subject to the second mortgage that we, of $250,000, that we say was obtained with a fraudulent power of attorney.
I understand. Mr. Gornick, can you please amend your notes regarding the order that I'm going to ask you to draft to include a partial stay in case ending 076 that stays Katie's counterclaims in her capacity as trustee? Thank you, Mr.
Well, those would only apply to the fourth and fifth claim, I believe, Your Honor.
What are the other counterclaims?
They related to the operating agreement and buy-sell proceeds, which you.
I think I resolved those.
Well, we think so, but I think in our negotiations, I think the other side thinks that maybe there's something there. We'll work that out. They're either resolved or they're not stayed, but I don't think.
I'm going to stay all of Katie's counterclaims for the moment. If through your discussions you think this is overbroad, I will of course consider a motion to adjust the scope of the stay. But we need to have some clarity when you all leave the room today.
Right. The problem is the first three claims relate to the buy-sell proceeds, which we thought was resolved.
The first three claims and the first three
First three counterclaims have basically parallel claims. So if you're going to stay Katie's counterclaims there, they've got to be stayed in the claims. They're
Are
the
they
same
just
claims.
declaratory judgment actions going like this?
Yes. We're entitled to buy proceeds. They say they're entitled to the buy sell proceeds.
Didn't I already rule
We-
on that? And the
that's-
buy-sell
think
proceeds
so.
were in fact disposed of?
So, in this, Your Honor, perhaps we should have asked for clarification at that hearing. Because in the way that the ruling was issued, it was that the assignment to the trust was effective. So the trust was entitled to receive those proceeds. They were, they asked for quite a bit additional relief in respect to those claims, and the court denied the remainder of the motion for summary judgment. So we think there's still issues to be addressed in that
Why
respect.
aren't those proceeds now in the trust estate to be distributed according to the terms of the trust?
Well, I guess we were taking the court's ruling, because I think they had, you guys correct me if I'm wrong, had specifically requested in their motion to be able to dispose or to, use the proceeds as set forth in the trust. And since that was not included in that portion of the ruling, that was
I
granted.
recall taking the position that the trustee of the trust would just exercise his or her fiduciary duty to do with the proceeds what the trust requires. I didn't need to make the order.
Understood, and if that's the order, then, then we understand.
That was our understanding, Your Honor. You didn't need to go there.
Need to pursue. We want to include that now, if that's not part of it.
Coming to the realization that what you previously agreed to was stay all of case 076.
Essentially,
Well,
except for,
not the home. The home ownership, personal property ownership. That's an issue.
Forgive me, we've taken a lot of twists and turns in this case. Is the home ownership still a live issue?
It
It
is.
is, Your Honor.
Okay.
Yeah, in some respects it is, yeah.
And which claim in 076 is that?
Your Honor, that would implicate Kouri's second, third, fourth claims for relief.
But the home was titled solely in Eric's name, correct? Corey's claim is to an equitable interest, correct?
Correct. We also have a pending motion for summary judgment on her third claim for relief that, with regard to tenants in common, that you stayed
Okay.
last time we were here, pending your resolution of the motions to stay. But that's been fully briefed and ready for a hearing.
I don't think I'm going to be able to, based upon your oral representations today, navigate how best to determine the motion to stay in 076. So why don't we back up a minute? I think my rulings regarding the motion to stay in 019 and 262 is appropriate, well-founded, it stands. The court is continuing any discussion or consideration of the motion to stay pending in case 076 to allow you all to meet and confer further, and then perhaps submit some final replies and tell me how you want me to rule given where we are right now.
Your Honor, I suspect, given your direction that you've given us today, I would anticipate we could work out a stipulated stay.
I am hopeful
We
that
see
you
where
do.
you're going, so.
Okay. Mr. Orange.
Case 230, you had previously said that was not stayed. Are you continuing that as well, or just for clarity?
That's the claim brought by Kouri against Katie as in her capacity as PR, right? Include that in your discussions. I remain a little fuzzy how it relates to the active claims in 076.
And we will do that, Your Honor. Just for your clarification, I think it's safe to say that the Kouri Richins versus Katie Richins Benson a case ending in 230 is almost identical, if not completely identical, to their claims in the 7-6 case.
Sounds like your discussions will be.
They just brought it
Okay.
against the estate instead of the trust.
All right. We'll see what comes out of this. Either file a stipulation or a request to submit, so I know to look there. All right. Mr. Orange, with respect to the court's ruling about the pending motion to stay in cases ending 262 and 019, please prepare a proposed form of order and serve it on Kouri's counsel for their approval or objection. All right. Okay. Mr. Tracy, Mr. Orange, anything further today?
No, Your Honor.
Mr. Dean?
No, Your Honor.
Richins, I wish you the very best. We will determine your next court date in the criminal matter after counsel have had some time to discuss a briefing schedule regarding the privilege issue on those two documents. I wish you all the very best. Please listen to the deputies as you file out to keep things orderly. Have a great weekend. Court's in recess. Thank you.